Good afternoon, everyone, and thank you for joining our webinar, Ballot Measures and Municipal Elections, What Local Leaders Need to Know. My name is Melissa Keene, and I'm a Senior Program Manager with the Institute for Local Government, and I will be your host and moderator this afternoon. Before we get started, just want to share a quick agenda with you all. We just have some quick logistics and introductions to get through, and then we'll jump into the presentation. We will hear from Chair Rich Madich with the Fair Political Practices Commission, Craig Steele with Richards Watson Gershon, and Dave Bainbridge, the General Counsel with the Fair Political Practices Commission as well. We will have time for Q&A. We'll share some additional resources with you all, and then wrap up and adjourn by 2:30. You've probably noticed that your line has been muted, and your line will remain muted for the duration of today's webinar, just due to the volume of participants that we have. But you can ask us questions at any point during the call. So on your right-hand channel, you should see a box that says questions on it. And you can type questions into us at any point in time. We'll be monitoring those throughout, responding as we can, and then we'll be pulling any kind of substantive questions for the end of the webinar. One other quick logistical piece, we will be sending out the recording as well as the slide deck to all of you on the line within the next few days. So keep an eye out for that, but we will definitely be sharing that with all of you, as well as some additional resources that, again, we'll chat about at the end of today's call. Just a little bit of information about ILG in case you aren't familiar with us. We are a statewide nonprofit affiliate of the League of California Cities, the California State Association of Counties, and the California Special Districts Association. We provide practical and easy-to-use resources so that local agencies can effectively implement policies on the ground. We have four main focus areas. We focus on leadership and governance, which provides things like your AB 1234 trainings. We do training and have resources around effective boards and councils, roles and responsibilities, working with staff, civility, things like that in that program area. In addition to that, we focus on civics education and workforce, which is really dedicated to trying to help create that pipeline to public service and get young folks interested in local government as a career path. This year, we're also really focused on the retention and recruitment challenges that a lot of our local government partners are facing right now. In addition to that, we have a program focused on public engagement. So that's everything from getting started to dealing with difficult meeting participants, to use of technology, or really substantive subject matter public engagement that we can help local agencies with, as well as a framework for public engagement that can help embed that into your operations. And lastly, we also have a program focused on sustainable and resilient communities. So right now we're doing a lot of work around housing and land use in that space, but we also do work around climate action, energy efficiency, greenhouse gas reductions, and things like that. We provide training and education, technical assistance, capacity building, and convening services to our local government partners. So if you haven't already, definitely go to our website. A lot of our resources are free. A lot of our trainings are free. We really just want to help you all do your jobs a little bit easier. With that, again, today's presenters are Craig Steele, who's a shareholder with Richards Watson and Gershon, Rich Madich, the chair of the Fair Political Practices Commission, Dave Bainbridge, General Counsel with the Fair Political Practices Commission. And first up, I'm going to turn it over to Chair Madich to just kind of set the stage for today's conversation and talk about why this subject is really important to the FPPC. Chair?
All right, great. Thank you, Melissa. Appreciate the introduction. And good afternoon, everyone. Thank you for the opportunity to speak with you today. So for those that aren't familiar with our agency, the FPPC is a nonpartisan, independent executive branch agency that administers, interprets, and enforces the Political Reform Act of 1974. And the Act, in turn, is a comprehensive set of laws that regulate campaign finance and government ethics at both the state and the local level. Now, most relevant to our discussion here today, the Act requires timely and accurate disclosure of political spending in state and local elections, including local ballot measure elections. And the policy goal underlying these provisions is simple. Voters should know the sources and amounts of money being spent to influence their votes before the candidate or ballot measure are actually voted upon. And so when it comes to local ballot measure campaigns, the Act's requirements actually intersect with other laws that restrict how local governments communicate to voters about ballot measures. Now, Mr. Steele is going to go into more detail about those laws later in the presentation, but the key point that I want to mention at the outset that the goals of each of these laws, as the PRA's transparency goals and the restriction on government spending in elections, are complementary in the sense that both seek to protect the integrity of our election process. And so, in light of that overlap, that is why the Commission, when we began to see an uptick in the number of complaints related to unreported government spending in local ballot measure campaigns, we determined it was appropriate to direct our staff to make this a priority area for our work. And this means a few things as a practical matter. First, from an enforcement standpoint, our staff will usually recommend higher penalties for unreported government spending in elections than in other types of cases where the degree of public harm is lower. We also have expanded our proactive efforts to identify government agency communications that cross the line into reportable campaign activity, including by making it easier for members of the public to report potential violations to us through our AdWatch program. Second, and equally important in my mind, we at the FPPC need to do more to educate agencies and public officials about the rules and to help you all comply and understand what types of communications cross the line and which don't. And I know the rules in this area can be complicated. Before becoming chair, I spent over a decade in private practice litigating and advising clients on government law matters. I have firsthand experience trying to explain to local agency and government agency clients how these rules are meant to work. And I know how crucial it is that public officials are able to effectively communicate to their constituents about the ramifications of proposed ballot measures without worrying about violating the Political Reform Act or other legal restrictions on campaign-related communications. And so that's why I'm pleased to report that our staff, particularly Mr. Bainbridge, who you'll hear from later today, have taken steps to improve our educational materials in this area. For example, we recently enhanced the information available on our website to include more real-world examples and references to prior advice we've given in this area. And as Mr. Bainbridge will talk about in more detail later, we recently issued an advice letter to the City of Riverside that contained a comprehensive analysis of several types of proposed communications from the city, so that you, public officials, and the public can better understand how our staff applies the law in this area. So I want to close by encouraging all of you to please make use of the resources when questions arise and seek out our assistance. I think I can safely speak for my colleagues on the Commission when I say I would much prefer to see these matters resolved through education and outreach and improved compliance than through enforcement matters, which at the end of the day, I'm not sure they really benefit all of you as much. So again, please make use of the resources we have available. And so with that, I'd like to turn it over to Mr. Steele and Mr. Bainbridge.
Thanks, Mr. Chairman. Appreciate hearing the FPPC's perspective on this, because over the years since Prop 218 was passed, the concept of public agencies' informational efforts in relation to ballot measures has really been evolving over the years. And as more and more issues are now legally required to be submitted to voters, whether they're tax measures or land use measures or even assessments, more and more over the years, the inclination of public agencies is to want to tell their story. And many of these ballot issues don't always appeal to kind of the traditional political interests in many communities. So it's tougher to get an organic kind of campaign committee and fundraising involved, which has been the traditional way of telling the story. So more and more public agencies have turned to communications consultants to educate the public before and after a ballot measure has been identified. And in many cases, in my experience, especially over recent years, those consultants have started to try to push the envelope in terms of what information a public agency can disseminate and in what form. And it really puts public agency staff and attorneys in a difficult kind of rock and hard place situation, because consultants will often say something like, well, I had a client in that community over there and this is what they did and nobody objected and that measure won, or something along those lines. And so it's really difficult to kind of push back or to try to find a more appropriate balance. This new focus by the FPPC, and in particular a couple of enforcement cases that came down that Dave is going to talk about last year, and a new advice letter that he's also going to talk about, really have given us more specific guidance as to where the boundaries are. And it really justifies another look, taking another look at where those lines are and how we can kind of stay within them. Next slide, please. I'm sorry, I missed it, missed my cue. There's three issues to talk about in terms of the legal framework. One is, you all know the authority for agencies to submit issues to the voters is in law, right? It's in the state constitution. There are statutory provisions. We know where that authority comes from. We can point to those rules. There's also statutory authority for public agencies to lobby the legislature on issues that are of concern to the public agency. So we can point to those rules. There's no legal authority for public agencies to lobby the voters, right? There's no legal authority for public agencies to campaign. And so the line is nowhere near as bright. And that's the line we're going to talk about today. Next slide, please. Jesse Unruh, the former California state treasurer, said that money is the mother's milk of politics. And it's especially true with regard to ballot measures. In ballot measures, it's all about the money, and especially in this context of public agency participation in ballot measure education, it's all about the money. Who's spending the money? What are they spending it on? And I think particularly significant in light of some of the stuff that Dave is going to talk about in the more recent opinions of the FPPC, when is that money spent? Is it money that's spent informing the population of a particular public agency about maybe the need for a ballot measure before that ballot measure is actually before the voters? Or is it spent on communications about a clearly identified ballot measure once the election's already been called? Because there's a line between preparation, deciding whether or not a ballot measure should go on the ballot, deciding what it should say, and the actual campaign in favor of or against that ballot measure. And so the timing piece of this is particularly significant. Preparation work prior to the time there's a measure identified is certainly different than informational work once a measure has already been put on the ballot and it has a title like Measure A or Measure B or whatever. There's another line to be watched out for, and that's the line between information and advocacy, because that line is not so clear. Next slide, please. That line really comes from a California Supreme Court case called Stanson versus Mott in the 70s. And that case held that without statutory authorization, public agencies may not expend public funds to try and influence the voters for or against a ballot measure. And there's a direct quote: "The selective use of public funds in election campaigns, of course, raises the specter of an improper distortion of the electoral process." The Stanson court, the California Supreme Court, really was getting at this idea of a public agency using public funds to put their thumb on the scale of an election. Maybe not so much as the case law evolved since Stanson, maybe not so much in the capacity of saying vote yes or vote no, but effectively saying vote yes or vote no by using public funds to kind of put the thumb on the scale. And so a lot of what we're going to talk about now is really aimed at that concept. Next slide. The Supreme Court recognized the informational role that public agencies must play. Somebody's got to tell the voters what the ballot measure says, what it would do. In fact, there are laws that say, for example, for a city measure, a city attorney must provide either a title and summary for an initiative measure or an impartial analysis for a ballot measure to tell the voters what it would do, emphasis on the word impartial. Other important things, takeaways from the Stanson case were the court noting the possibility that a public official could be personally liable for improper political expenditures if that was done, quote, in the absence of due care. And there have been instances, rare, but there have been instances where public agency staff members or officials have been held personally liable to pay back improper political expenditures. And the court noted this dichotomy between campaign activity and informational activity, and acknowledged that it's sort of like one of those "I'll know it when I see it" type of instances where, in most cases it's fairly easy to see vote yes or vote no as being campaigning. But once you get past that and into more sophisticated rhetoric, there's a question about whether that rhetoric in public agency communications is going to be deemed to be advocacy, campaigning, or informational. And Dave will talk about a regulation that helps make that determination. My feeling is that, the envelope for public agency communications is large enough as it is, and especially in light of what the chair was just talking about and the more recent activities of the FPPC, we shouldn't push that envelope. There's enough room for telling a factual story about a ballot measure within the existing laws without pushing the envelope and moving over into trying to convince the voters. Stanson versus Mott really gave rise to kind of 4 pieces of law. They're all, arising out of this philosophy that was articulated in the case of the public agencies not putting their thumb improperly on the scales of elections. One law that I'm going to talk about just briefly limits what kind of the administrative state, what staff can do and can't do in relation to elections. Second is more limiting on the activities of elected officials. And the third is a criminal provision that allows district attorneys the flexibility to sometimes prosecute these kinds of violations in the criminal context. And then the fourth is in the FPPC's area of responsibility, the law that the chairman just talked about a minute ago that Dave is going to cover, the transparency angle of it, reporting resources that are spent on election activities. I would just say before we get to that fourth piece of it, what we have to remember is if you get to that fourth piece and the FPPC tells you that as a public agency, you have to report the money that's been expended in favor of or in opposition to a ballot measure, it's pretty clear that you violated one of the first 3. So, I think the FPPC's activities in this area is certainly the most active enforcement activity going right now. But it's not a situation where a public agency can say, well, we'll just make the decision to report these expenditures and we'll comply with what the FPPC wants. Once you comply with what the FPPC wants, the transparency portion of this, it's a pretty clear indication that your agency has probably violated one of the first 3 laws that I'm going to talk about now. Next slide, please. Government Code Section 8314 prohibits a local agency officer, employee, or consultant from spending or authorizing the expenditure of public funds to support or oppose a candidate or ballot measure. That's a pretty clear prohibition, except there's an exception in the law for a fair and impartial presentation of relevant facts to aid the electorate in reaching an informed judgment regarding a bond issue or a ballot measure in communications that are otherwise permitted by law. So we'll talk about kind of ways to fit within that exception in a minute. You should know that there's possible individual liability for a civil penalty of up to $1,000 and up to 3 times the value of resources that are spent in violation of this section for intentional or negligent violations. So, technically reading this statute, a public official that approves an expenditure of public funds to support or oppose a candidate or ballot measure, and it doesn't fit within this exception, could be liable for up to 3 times the value of the money that's been illegally expended. That's a pretty serious individual personal consequence and a reason to be cognizant of these rules. Next slide, please. Government Code Section 54964 is more, I think, restrictive on the elected officials, although it includes employees or consultants, but really says that these folks may not expend or authorize the expenditure of public funds to support or oppose a ballot measure or a candidate. And all the definitions in this section really relate back to the definitions of contributions and expenditures in the Political Reform Act. So basically, if you do something that needs to be, make an expenditure that needs to be reported under the provisions of the Political Reform Act, you are admitting a violation of Government Code Section 54964. It requires a clearly identified measure or candidate. It requires that an expenditure be made for express advocacy, and we'll get into that definition in a minute. It also provides that a violation of this section is a misdemeanor. Again, serious consequences if you're using public funds to try to influence an election. Next slide, please. Finally, Penal Code Section 424 is generally a section that prohibits misappropriation of public funds, either for illegal purposes, for personal purposes, or for political purposes. Most often you see this section prosecuted by DAs for things like illegal use of a public agency credit card for personal expenses, or those kinds of violations. It's also possible that a district attorney in a given situation could prosecute a public official for misappropriating public funds under this penal code section if that public official, for example, spent public funds on their own campaign or to support a ballot measure. Rare, admittedly, but it's out there, and it's a misdemeanor or a felony in the determination of the district attorney in filing the charges. So again, a good reason to not try to push the envelope on these types of expenditures. And now I'll turn it over to Dave to talk about the fourth element of those laws.
Good afternoon, everybody. I'm Dave Bainbridge. I'm the General Counsel at the FPPC. As we've heard from Mr. Steele and Chair Matich already, there's a number of areas of laws that touch on this issue of local agencies spending public money on campaign activity. And the Political Reform Act is one of those areas. Unlike the other areas that restrict the use of the money, the Political Reform Act requires reporting of money spent on campaign activities by public agencies. And so we have kind of a strange area of the law where there are, it's something that is restricted in other areas, but required to be reported by the Political Reform Act. And as Mr. Steele mentioned, if you get to the point where you're supposed to be reporting on as a campaign committee, you've already violated other sections of the law. But what is useful that the FPPC has is a regulation that attempts to delineate when communications by an agency cross the line from being educational and go into becoming campaign activity, which is what is prohibited. It is not prohibited to communicate with constituents, to provide information, to discuss ballot measures. It's not prohibited for the agency to state its position on a particular measure. What is prohibited is attempting to influence. And so our regulation, the FPPC's regulation in this matter tries to explain exactly what the when you go from being educational material to being advocacy, which makes it campaign material, which then if it's spent in any amount of money that's above $1,000 is going to trigger campaign reporting as well as advertising disclosure requirements under the Political Reform Act. So what I'm going to do now is I will go through the relevant regulation and kind of walk through it and give the basic elements. And then what we'll do is look at the most recent or fairly recent case involving the County of Los Angeles, and then also the advice letter that Chair Matich mentioned earlier. It provides a good sort of sample case of how we view the requirements of the regulation. So we can go to the next slide. Regulation 18420.1, the Commission adopted about 13 years ago, the current version. And what it does is it's based on the Stanson case previously discussed and then a subsequent Vargas v. Salinas case. And it creates a standard based on those cases of the definition of campaign activity for public agencies when putting communications out there to make the distinction between campaign and educational. The goal in our reg is to make it the same standard as what is prohibited, so that there's no gap between what is prohibited and what must be reported. So when you look at the regulation, it's taken straight from that case law. So Subdivision A provides that payment of public monies by a government agency will be considered a campaign expenditure or contribution if it either does one of two things: either expressly advocates or unambiguously urges a particular result in an election. So expressly advocates is the so-called magic words: vote for, yes on, that sort of thing. That's pretty easy. If you see that, you're done with your analysis. Lucky you, you don't have to go through the next subdivisions. So anything that has those magic words is going to be express advocacy. It's going to trigger the reporting requirements if over $1,000 for independent expenditures. The more nuanced analysis is, in the more common situation, is the unambiguously urges a particular result in an election standard. So we'll go to the next slide, which gets into that, defines that. Okay, so unambiguously urges a particular result in an election. There's really two ways that we can find that. One is if it's clearly campaign material. This is, you look at the material itself, the communication, and it looks like a campaign material. Examples, and these examples largely come from the Stanson case, are bumper stickers, billboards, television and radio spots, the sort of things that you look at them and you know by just looking at the face of them, these are campaign. The second category are communications that, where you look at the style, tenor, and timing of the communication. So rather than just looking at the communication itself, you look at the circumstances that surround that communication to try to determine if the intent and the effect of the communication is that it unambiguously urges a result in the election. And I think it's important when you look at that language there in Subdivision 2, it's a reasonably characterized as campaign material and not a fair presentation of facts serving only an informational purpose. So on one end, you're looking at whether it could be reasonably considered campaign material. On the other, it has to serve only an informational purpose. So I think that often is what will tip the scales towards something being campaign activity versus educational, reasonably versus only. All right, we can skip to the next slide. Okay, and I went in order of the subdivisions just because I think it makes the most sense of organizing, but this Subdivision C speaks to what are direct and indirect costs. So in looking at a communication, if the communication is campaign material, it's all the costs involved. It's not just the cost of the actual ad. It's computer usage software. It's anything you can think of that goes into creating the advertisement. Again, if you're at this point of looking at costs, you've already violated other parts of the law, but it's the total cost of the communication that will trigger the Political Reform Act reporting and advertising disclosure requirements. All right, we can skip to the next slide. Subdivision D provides some gloss on what style, tenor, and timing means. So we had talked about, when you're looking at whether something unambiguously urges, if it's not express advocacy, then you look to see the style, tenor, and timing of the communication. And the regulation lists a number of factors that you would consider. It's a non-exclusive list. So you can consider any number of factors in looking at whether communication based on its style, tenor, and timing is intended to urge a particular result versus solely being educational material. So, and these also come from the case law. So if it's funded with a special appropriation as opposed to using general funds that already exist, whether it's consistent with a normal communication pattern of the agency. You know, a lot of agencies send a quarterly newsletter to their constituents. Something in that would be looked at differently than if it was a special communication that's not normally sent. Similarly, number 3 is a style of other communication used by the agency. Again, if it's something that's similar to what the agency sends on a regular basis, it's one thing. if it's something that is unique, if it looks like a glossy campaign mailer as opposed to a letter which is normally sent. Those are the sort of factors that we would look at to see if the style, tenor, and timing is that of a campaign communication as opposed to an educational one. And then the fourth category, which is probably the most debated and least sort of definitive, is whether the communication uses inflammatory or argumentative language. And we'll look at some examples here in a minute that will give you an idea of what the FPPC sees as being inflammatory or argumentative. Those terms largely are intended to mean, instead of being information, it is more sought to appeal to maybe an emotional or provide, it looks like an argument and not information, a neutral information. So that is the basics of the style, tenor, and timing. Again, it's not an exclusive list. You can consider other factors, but you're looking behind just the face of the communication and looking at the circumstances surrounding it. Okay, next slide. Certain communications are by law permissible. You don't even have to do the analysis if it's one of these sort of communications. So I think you'd be well served if you wanted to put out a communication to look at these exceptions and use these sort of communications to educate the public. So we can skip to the next slide. You can look at those on your own for the specifics. All right, and then subdivision F just reiterates that if a state or local agency spends sufficient money on communications that qualify under this regulation as campaign communications, they will qualify as a campaign committee, just as any other entity would that was participating in campaign activity, and have the same reporting requirements and disclosure requirements and advertising disclosure requirements as any other committee. All right, we can go to the next slide. Okay, so recent case that the FPPC issued a decision on, approved a stipulated settlement amongst the parties, is the matter of the County of Los Angeles. This involved a Measure H put on the ballot by the County Board of Supervisors in March of 2017. Measure H was a sales tax increase that was projected to raise $355 million over 10 years to combat homelessness in the county. The county in this case hired a so-called educational campaign consultant. The consultant specialized in getting measures passed, was the way it promoted itself. The county spent about $1 million in association with this contract for TV and radio ads and electronic ads and that sort of thing. The TV ads ran on cable news. The radio ads ran on local radio stations and news radio stations. And the ads featured formerly homeless people that were profiled, vignettes on people who had been homeless and had been helped by the existing county program that they were seeking additional funding for through this Measure H. And the commercials really projected the program in a positive light. They did not contain any express advocacy, but they couldn't be categorized as educational either. They didn't provide information about how much the sales tax increase would be. It was an appeal to look at the positive things that this program has done for the people who are profiled in these TV and radio commercials. And so in doing the analysis that we just talked about in the regulation, we looked at it and they didn't have express advocacy, but they unambiguously urged a particular result in the election. In our mind, they were clearly campaign material by their very nature as a TV commercial that was clearly intended to encourage people to feel a certain way about the measure and to vote a certain way. They aired so taking a step back. So that was clearly campaign material, which if you look at the analysis, that can be the end of it. You meet the unambiguously urges, you have campaign activity. But if we also looked at the style, tenor, and timing, if the other part of the test, and I think it's instructive to look at it from that perspective as well. The ads ran right before the election, which was in March of 2017. And then, so it was not a normal, normal course of communications of, putting television commercials on cable news. They also contained some language that I think was convincing that these were campaign ads. They touted the Los Angeles County Homeless Initiative, an existing program. It included the logo of the program. They had the tagline, and this was all after running the piece about the formerly homeless person who had been helped by the program. They included the phrase "real help and lasting change" as their tagline. And then it said, "Measure H on the March 7th ballot. Are you ready? Vote March 7th." So not express advocacy, doesn't have the magic words, but it's certainly, when you look at it, you can tell by just watching the commercial what they are leading you to, what they are encouraging the voters to do. So that was the matter of the County of Los Angeles. That was kind of an easier one because it was television commercials. And then, as Chair Matich mentioned, and Mr. Steele had referenced as well, last year we had an advice request from the city of Riverside. And we can go to the next slide. Okay, and Craig, if you want to jump in at any point, feel free to cut me off, but I'll go through this letter, and then we can look at some of the advertisements that the city of Riverside was considering putting out there, and they had asked our advice on whether we thought it would trigger campaign reporting requirements. So the ballot measure at issue here was one to raise or to transfer public utility revenue to the city's general fund. So they had put the city had put this measure on the ballot. It was the only measure on the ballot. It was actually a special election that was to be held in November of last year. And the city expressed concern about confusion because of the governor's recall, which it's hard to believe was only last September. But due to the two elections, they were concerned, one, about people being confused as to what was on the ballot when, and two, I think there was some concern about getting people to come out and vote again, considering there might be some fatigue from all the elections just a couple months before. Okay, we can go to the next slide. So here's one of the proposed communications that the city sent us. So what the city did, and they did it the right way, which was they asked us through their council in advance of actually producing these communications. They had mock-ups and said, do you think under your regulation this would be considered campaign activity versus educational? So the first one we're looking at here is it was going to be on the city's webpage. And these were really tough because they were very close. It was a very, very difficult analysis to determine, is this educational, again, only educational, or could it reasonably be considered campaign activity? So in analyzing this, we've sort of highlighted some of the important considerations that we looked at. I think of note is the fact that this was going to increase, the proposal was to increase funds to the general fund, but it's not clear that it was for everything. They highlight certain areas to sort of lead you to conclude that this is what the money would be spent on, even though it wasn't limited in any way. Obviously, it probably would be spent in part on these different services highlighted, but it was noteworthy to us that the services highlighted are ones that are typically more popular or less controversial. So that in and of itself wouldn't make us conclude necessarily that it was campaign activity. I think the paragraph there at the bottom, second to the bottom there, that's highlighted was really what in our mind pushed this into the category of being advocacy as opposed to education. And this goes back to the standard of whether the material is inflammatory or argumentative. And here, the way the paragraph is written, it would lead you to believe that without these additional funds, there was serious threat to the public. It even uses the term save lives, with the implication that if you don't vote for it, you're not saving lives. So this ultimately, in our mind, tipped the scale from it being solely for an educational purpose and into the category of advocacy.
Dave, can we, before you go on to the next example, can we talk about the use of the FPPC advice process for a second? Because I think you made a point that we should emphasize, which is Riverside tried to do this the right way, right? They wrote to the FPPC for advice in advance, saying, here's what we're thinking about doing. What do you think about it, right? And I would just say, in regard to that, I think the FPPC would join me in saying that's a good way to go about it, because you're asking for advice before you've taken the action. And the rule is that if you ask for advice and the FPPC gives advice before you've taken the action and then you follow the advice, you can't be prosecuted for a violation for following the advice. And so, I think the FPPC does that as a great service to the people that they regulate, the entities that they regulate. You just have to understand that once, as a public agency, you ask for the advice, then if you ignore it, you're ignoring it at your peril. So that's one thing that I would say about the advice process. I think Riverside, did a commendable thing trying to get on the record as to whether this was the right thing to do or not. But I also think, in my view, and Dave, you probably won't be able to agree or disagree with me on this. In my view, the LA County case was an abuse of the advice process, because, as I understand it, just from reading the documents, the Howard Jarvis Taxpayers Association, the way this all came about was the Howard Jarvis Taxpayers Association wrote in for advice sort of with some generic, they said, campaign type activities, asking whether or not those activities would be violations of the Political Reform Act. Well, in fact, what those generic activities were the things that LA County was planning to do. And once the FPPC wrote back and said, if a public agency did this, it would be a violation, the Howard Jarvis Taxpayers Association essentially turned around to LA County and said, aha, and sued them. And that was really how as I read the documents, how the situation came to light. Doesn't mean what LA County did was right. It just means that public agencies should be aware that there are organizations like the Howard Jarvis Taxpayers Association out there looking for these kind of violations, because that association made $1 million in $900 and some thousand in penalties. So there are organizations out there looking for these kind of violations, and it warrants another reason being careful about these kinds of expenditures, because there's a lot of focus on this type of activity these days.
I think what I would add to what you said about the advice function earlier is, yeah, one important thing is that you ask before. We can't give advice on things that have already happened. And so you have to ask before. And then also, our advice function is not an official opinion of the commission. The commission doesn't vote on it. It's a service provided by the staff of the commission and required by statute to advise people on how they can comply with their obligations under the act. So some of you may be sitting there going, you're crazy, this isn't advocacy, this is education. And I acknowledge that some of these are right on the line. And we're kind of picking at nits here, trying to figure out which is advocacy and which is education. But our job is to advise on how to comply with the law. So we're going to naturally err on the side of being more conservative and telling people what they should do to ensure compliance, as opposed to trying to tell them exactly where the line is on some of this stuff.
And would you agree, knowing that you can't give a specific answer to a question about a specific piece of literature, because it might come before the FPPC, totally understanding that, would you agree that you could look at this FAQ document and with a few relatively minor changes that are kind of indicated in the left-hand margin there, you could make this a compliant document, right? I feel like this could be written in a way that would have passed muster had it, had with the benefit of hindsight.
Yeah, actually, I think that leads us well to the next slide. Let's go to, if we can go to the next one. So this was an FAQ that the city of Riverside also had asked about. Has a lot of the same material. We ultimately came down on the other side of finding this to be educational. Even though you see a lot of the same things that are highlighted, mentions, sort of the more favorable, typically less controversial services provided at the local level. And it also, but the other thing that it doesn't include that third paragraph that I mentioned that we thought was inflammatory and argumentative, and it provides more information as opposed to advocacy. So specifics about whether the Measure C raises taxes or fees, and information about the election and this concern about the recall and there being confusion or fatigue, which was their stated reason for wanting to do this educational campaign. So these are all factors we would look at. So it's hard to change just one thing and say this would make it permissible or this wouldn't necessarily, because it's a very broad, overarching look at everything that went on involving these communications to determine, to look at the style, tenor, and timing, because again, it's not just based on the face of the communication. And then they also talk about how do I vote? So information about voter outreach, all perfectly valid, helpful information for the public. And so that's why this FAQ came out differently than the previous website, even though some of the material is the same. There's more information, and there isn't that one paragraph that we deem to be argumentative. All right, we'll go on to the last example here from this advice letter. So this one is interesting because it's a utility insert, which are pretty common with your utility bills, and something that the city of Riverside did on a semi-regular basis, I understand. So typically you'd think normal course of communications. However, the appearance of it looks very much like a campaign mailer. It's designed in a way to highlight certain facts. It has information, again, that is typically deemed good uses of municipal money. And then it also contains the language there at the bottom that's highlighted. Sorry, it's kind of small. But this is the inflammatory, argumentative type language that we had identified in the past, or similar, that put us in the category of deeming it campaign activity for the website. So here you have a utility insert, which is, I think, more often than not going to be looked upon as being informational, because it usually tells you when you can, put your large items out on the street, or whatever else they want to inform you about. And it just so happened right before the election, this version came out and it looked like a campaign mailer and contained this language, which was why we concluded this would be campaign activity if they were to include it along with utility bills. So as you can see, I think you have to take all of these things into consideration, and it's not an easy analysis a lot of times to determine whether something is going to trigger the campaign reporting requirements. I would say, while it's tough to know where the line is, I think, and Craig's going to talk about this a little more, it's not hard to follow the law and make things educational. It's harder to know exactly where the line is. But if you keep it educational, provide all of the information, provide both sides, and don't try to appeal to an emotional or that sort of side of things, I think you can craft some fairly effective educational materials if that's your goal. All right, we can go to the next slide. Okay, and just to unless Craig, you had anything else on those examples?
Not on that one, thanks.
And here we have some resources and advice. As Chair Matich mentioned, we're here to help. We're here to keep people in compliance. So I think your first step is always consult with your agency counsel. They're all very well versed in this area. And then if after that they have questions, or you continue to have questions, we have a guide on our website. It was just updated and the new version went up yesterday. Has lots of information, summary of this area of the law, as well as recent enforcement cases, as well as recent advice letters in this area. So I would encourage everyone to check that website out. And after that, if you still have questions, you can always write into our email address, advice@fppc.ca.gov, and we can advise you on what you need to do to comply with the law.
And I think that latter piece, just to reemphasize the advice function that the FPPC provides, if you have time and if you plan ahead, and we're going to talk about planning ahead here in a minute, it is a really helpful service that the FPPC provides. I think the additional information that's on their website is really helpful, and for folks who haven't looked at that stuff in a long time or don't have occasion to practice law in this area all the time, it's really helpful to see what the FPPC thinks about it, because as we've said before, this is where the active enforcement is. It's much more likely now, I think, that the FPPC is going to be involved. It's much more likely that they're going to get complaints about informational activity than, for example, your average district attorney. And so it's really helpful in terms of deciding what is okay for your agency to do, to look at the resources that the FPPC provides. And especially, I would say for the lawyers on the line, read the Norton advice letter, which is publicly available, because it really provides a helpful kind of roadmap of how the FPPC looks at these issues now. Next slide, please.
All right, before you jump back into this content, we've just been getting a few questions that I want to address really quickly. For those of you that joined us a little bit late, we will be distributing the slide deck and the recording to all of the folks on the line after the fact. So you don't have to be seriously taking notes as to all of these explicit code sections and things like that. We will be sending this out for everybody's reference after the fact. And then just a quick reminder for folks that you can also send us in questions by the question box on the right-hand channel of your screen. And we're tracking those, and we'll be getting to them towards the end of today's webinar. So sorry to interrupt your flow, Craig. Just wanted to address that before we moved on.
No worries. I appreciate the chance to get a drink of water. So I just put the definition of express advocacy back on the screen because, just to sort of refocus what we're talking about. It's the line between express advocacy and the kinds of things that were asked about in the Riverside letter that Dave just talked about. This stuff is easy, right? Everybody can look at this kind of language and say, all right, a public agency can't do this. You may think a public agency should be able to, you can't. So this is the easy side of the line. We want to talk about the other side of the fine line, and three words that Dave reiterated and talked about that appear in the case law and in the regulation are really important, and style, tenor, and timing. And those are the things that the enforcement authorities are going to look at to determine whether a communication is advocacy or information. Style really means, what does it look like? Does it look like a campaign material, or does it look like the normal communications of a public agency? And the examples that were shown from the city of Los Angeles, for example, if you looked at those, you would say, well, that's really sophisticated political campaign stuff. It's not the normal communications of the county of Los Angeles. Because it looked like campaigning, right? It had slogans, it had graphics. I think one thing I can tell you pretty emphatically is that if your public agency is paying for digital advertising on Facebook or Twitter or wherever about a ballot measure, that's a style that's gonna evoke notice as being related to a ballot measure and intended to influence a result, because public agencies don't normally buy digital advertising, and they certainly don't normally buy digital advertising that's targeted in the way that digital advertising on social media, for example, is targeted. So that's a kind of example of what we're talking about when we say style. The second thing that I think is the harder concept is the concept of tenor. And it's really, it's about rhetoric. Is it a piece of communication that's intended to result in somebody doing something, or is it, kind of impartial in tone and just, like reading out of an encyclopedia. Now, I'm not saying that you have to go that far in holding back on the tenor, but some of the highlighted text that Dave showed you, basically this measure would save lives, is a tenor that's not necessary to inform the voters. It's intended to produce a result. And so when I say you could look at that first document that Dave showed you, and by changing up, not too many words, turn it from a document that has a tenor of advocacy into an informational document that probably would have gotten approved. Now, does that mean I think that the FPPC got it right in the Norton letter? I would probably argue against some of the conclusions in that letter, but that's the authority that's out there. I'm not a judge. I'm not the FPPC. I don't get to, wave a wand and make those decisions. I don't think it's as clear as it's made out in the Norton letter. And I have a feeling that these issues will get litigated some more and we may get more kind of definition. But what I do know is that's the authority that's out there. And that's the signal. You've heard it from the chair of the FPPC of their emphasis on these issues. And now you know what the FPPC's opinion on some of these kinds of communications are, and we should all pay attention to it. Again, I don't know that I would have come down in the same way on all of these issues, but we'll get some more definition from the courts. And until we do, it's more important than ever to focus on this distinction between information and advocacy. Next slide, please. There's a fine line, as I've said many times before. Obviously, that vote yes, no thing, anything that's result oriented, anything that appears to be one-sided or emotional, people are going to die if this measure doesn't pass, or this measure will save lives, as the Riverside communication implied, I think is going to, come down on the side of advocacy, unambiguously urging a particular result. One thing that consultants talk about a lot that I think you all should think about before approving expenditures is whether communications are targeted. If a communication is targeted to the voters, that's going to be a pretty significant indicator that this was intended to produce a result in an election. Now, some kinds of communications that are targeted to the voters are not going to be like that, right? You saw the example in the FAQ document a couple of slides ago where it was obviously targeted to voters because it was explaining the timing of the election. It was explaining, what a yes vote or what a no vote meant. That's obviously, information that voters on both sides of an issue or undecided voters need to get. But when targeted information like the County of Los Angeles was using is going to people who's, basically saying cure homelessness, vote June 7th, it's pretty hard to conclude that the purpose of those communications was anything other than to get a $350 million tax measure approved. In my opinion, there are ways to disseminate impartial information and show that it's impartial information. One way is that I think is really important to talk about is to attribute the information that you provide, right? Provide factual information and attribute that information to the person or the entity that said it. You'll notice if you read the Norton advice letter, there's a footnote in there that's actually really important, and it's a footnote that talks about a case called Vargas versus City of Salinas and cites a passage from that case that basically says that the city took care to only refer to information that had already been adopted by the city council. In that case, many years ago, the City of Salinas City Council, as I recall, took action to say, look, if we don't get more money through a tax like this, these are the services we're going to cut. And they had a list. And then the information that went out to the voters was attributed to the City Council. It said the City Council has decided that these services are going to get cut if they don't get revenue. It's hard to do anything other than to say that's just information. It's stating a fact. It historically happened. It's a public record. It may be emotional, it may be intended to provoke reactions by the people who adopted it, but it's a statement of fact. I have in past ballot measure communications, I have advised clients to have workshop sessions before a measure is put on the ballot. Get the information out there to the city council, whether it's in a memo from staff or a report from the city manager. Here's the state of our finances. For example, if an agency is discussing putting a tax measure on the ballot, here's the state of our finances. Here's what we've got to figure out how to fund. Here's our budget deficit. Here's how much money Sacramento has taken away from us over the years. Put that information out in public so that there's something to cite to, and there's a record of why a measure was ultimately put on the ballot. I also think it's important to be able to show that you're telling both sides of the story. It's not that hard to say, we think we're going to have to cut some services if this measure doesn't pass, but we're going to try to find other revenue sources. Or some people say we can find other revenue sources, something like that. I think it's important indicator that something is impartial if it's widely disseminated and not just disseminated to likely voters, for example, right? If the city manager does a newsletter, or the city does a newsletter and there's an article in there about a ballot measure and the need for a ballot measure, that piece of information should be disseminated to the entire community and not just targeted to likely voters, because it shows you're informing the public and not just aiming at informing voters. And I think it's really important that your communications be consistent in style, tenor, and timing with the normal communications of the agency. So if you have a normal layout for recreation newsletters or reports from the city manager or the quarterly mailing, you shouldn't adopt some new type of style that looks like a political piece. If you have normal communications tenor, it's very informational. You don't want to go as Riverside tried to do with the more emotional stuff just because it relates to an election. And in terms of timing, I think what we learned from the LA County communications is that that communications that are contrived or that are scheduled just after a vote to put something on the ballot are going to be more likely to be viewed as timed to coincide with an election. LA County decided to pay $1 million for communications after the measure was put on the ballot. And to show that it was related to the ballot measure, they adopted a special budget appropriation to pay that $1 million. And that was kind of a key piece of evidence that the FPPC looked at to say, well, this is all related to communications. It's not the normal style or timing of LA County's communications. I think being prepared, communicating before a measure is on a ballot is really important. Being prepared in terms of having communications budgets available to put out impartial information even after a measure has been scheduled for the ballot is important. Special appropriations or targeting those kinds of activities are going to show that you're really trying to influence the voters and be deemed to be violations of some of these laws. Next slide, please. I would, just to kind of complete that thought, there are ways you can avoid what I think, we could call hidden advocacy, or the kinds of advocacy that the FPPC identified in the Riverside letter that you just saw some of those pieces. Again, make sure that that style is consistent with other communications. I bet that utility bill insert did not really look like other utility bill inserts, and calling it a voting guide on right at the top, those kinds of things. Probably not very consistent with other communications. We talked about the tenor, but one thing that we always try to emphasize when we're reviewing communications is saying things like "if passed," and not when passed, not making promises in impartial communications about ballot measures. I think that explaining the process, as Riverside did, in terms of when the election is scheduled, how you get a ballot, how you return a ballot, all of that kind of stuff is certainly permissible. And there's even a case out there that says that voter registration, spending city funds on voter registration, is a permissible expenditure of public funds, as long as you're being impartial and registering everybody that wants to register. In a case several years ago involving the city of Irvine decided to spend a lot of money on voter registration and get out the vote activities in the city, because there was a Orange County measure that was on the ballot that would have severely impacted the city. And they knew that people in the city were going to vote, I think, against the measures, I recall. And so the city spent a lot of money on explaining the process, telling people when the election was, registering them to vote, telling them to go out to vote, without ever saying vote yes or vote no. And that was the subject of a reported decision of the Court of Appeal. And the city's expenditures in that case were upheld, because all they were trying to do was get people to go vote. And it was noted that most people would vote the way the city wanted them to vote, but all of their communications were aimed at just getting people out to vote. And so we've talked about timing. Again, I think it's really important to do a lot of information before a measure is identified, which requires planning ahead. Because all of these laws really refer to clearly identified ballot measures. So until there's a ballot measure, you're really talking about possibility rather than an actual ballot measure itself. Next slide. Permissible uses of public resources. There are cases or statutes on all of these things. Drafting a measure is, hiring the attorney to draft a measure, or staff time, is clearly a permissible use of public resources. There's an advice letter and an attorney general opinion that says that public funds can be used to pay for polling pre-measure to help a public agency decide whether or not to put a measure on the ballot, and even what it should say. As we've been talking about, impartial information is always permitted. Voter registration, get out the vote. A lot of agencies don't know that a public agency board or council can take action to support or oppose a measure that affects the jurisdiction formally. So a city council can adopt a resolution supporting or opposing a particular ballot measure that affects that jurisdiction. What they can't do is then spend money publicizing that resolution. But the resolution itself, I have drafted and I have seen resolutions that are pretty explicit about why a city council supports a particular measure. And as long as that's done in an open and public meeting, with public having the chance to comment on it, that's a perfectly valid action for a city council or an agency board to take. And what the campaigns, the advocates on either side do with that resolution from there is up to them. But a lot of agencies don't know that it's permissible to take that resolution, adopt that resolution in support or opposition, not a candidate, but supporting or opposing ballot measures. And finally, responses to requests for information. If people call and say, I want a speaker at the Kiwanis Club about why this measure is on the ballot, staff can go out and respond to those requests for information. They can send the resolution, they could send that FAQ document or something like it in response to a request. Next slide. Prohibited uses, clearly prohibited production and printing of campaign literature, whether it's express advocacy or the kind of sort of hidden advocacy we've been talking about. I just think digital advertising, although there's not a particular reg, I think social media, digital advertising is just pretty clearly campaign activity. And the rest of these are pretty self-explanatory, except for the last one. Just keep in mind that there is a a rule that prohibits mass mailings at public expense if they feature an elected official or they are, contain express advocacy on a ballot measure. So the newsletter that goes out, you have to remember if there's more than 200 copies of it, it can't have a photograph or a signature or a title or something of an elected official, especially during campaign season. That tends to happen sometimes. Next slide. There are rules about what public employees can and can't do with regard to campaign activities. Cannot campaign during compensated time. They cannot be coerced or directed into working on campaign and off hours. You can't direct staff to go work at a phone bank or something in favor of a ballot measure. Cannot use the public agency resources or technology for campaign activities. And public employees may not campaign in uniform. Sometimes you have those requests where the campaign wants to take a picture of the firefighters in front of the truck or something like that. If that's specifically for a campaign activity, the employees cannot do it, and you should advise your employees that they cannot campaign in uniform. Also, they're not allowed to circulate petitions on official time. They're not allowed to solicit or either directly or indirectly a political contribution from another employee. So sometimes you see a city manager or something will suggest that the department head should contribute to the campaign committee. That can't happen, and especially can't happen in City Hall. And employees cannot promise an employment action in exchange for a vote. I think that the takeaway from this is, when in doubt, it's probably advocacy. If you're sitting around thinking, boy, is this advocacy or is this really information? And you're talking to a consultant about that, my guess is that it's probably going to be deemed to be advocacy, at least for the time being, under the new authorities that are out there. And the stakes are too high to push the envelope. We've talked about criminal penalties, financial penalties, in some cases, disqualification from office. Certainly for employees, it's possible there could be discipline or termination. The stakes are too high to push the envelope. And that's because there are plenty of ways to get the message out in an impartial, factual way within kind of the boundaries of the envelope without pushing the envelope. And so I'd urge you to consult, as Dave did, with the agency attorney in advance or with the FPPC in advance, because you may find that, next slide, please. Some of those, I've got one more slide. Sorry, I didn't catch up. One more. There are ways to get the message out without running afoul of these laws. The most common one is to make sure there's a campaign group that's registered with the FPPC, that's raising its own money, and doing the work of persuading voters to vote for or against the measure. Now, that may require elected officials on their own time to do that organization and to hit up folks for contributions. It may also involve, executive staff of people who think that a measure is important to do some of that organization on their own time. Again, public employees, public officials on their own time without being coerced can do that organization work and get the community going on an actual campaign. That's what we want, is we want the transparency of a campaign actually behind advocacy. You also can tell the story of the public agency's position in an impartial way. It's not as sexy, it's not as obviously impactful to voters, but if you've got a good story to tell and you're telling it clearly, impartial education can still be the information that voters need to make their decisions. Make staff available to respond to requests for information, but all in all, do it on your own time. Do it without the use of public resources for advocacy. There's a list of questions on the next slide, or common issues that come up, but maybe Melissa, now might be the better time to see if we have questions from the panel and bring Dave back on, and if not, then I can cover some of these issues.
Yeah, we do have quite a few questions. So and I think we might touch on some of this through these questions. So if we want to jump into maybe a Q&A, if that works, and then weave some of this in as appropriate.
Sure.
Okay. Back on camera too, so I'm not just a voice in the background here. Perfect. Okay, and then just a quick reminder to the folks on the line, as I mentioned, we do have quite a few questions in the queue, but if you've got additional questions, please feel free to type them into us now. Let's see here. So Craig, you did just touch on a governing body, a council or a board of supervisors being able to adopt a resolution for or against ballot measures. Are there any bright lines or guidance that you can give around individual elected officials, you know, making media appearances or, you know, campaigning in a sense on their own, just anything to that effect as it relates to the elected officials, not staff?
Well, the elected officials, and in most cases in California, obviously you're not full-time, you're volunteer or partially compensated elected officials. As long as you're on your own time using your own resources, there's no rule against advocacy in that capacity. Now, you know, the key part of that is being on your own time and not using public resources. Some cities have rules, and you'll just have to check in your own case about using the title, right? Can you say you're a city council member if you're out doing, you know, political activity, or do you have to identify yourself differently? That's really more of a local rule. But on their own time, as an individual and not using public resources, these laws don't limit that activity.
Perfect. This was what I thought was an interesting question that came up as it relates to public meetings. So obviously in your general city council meeting or board of supervisors meeting, there's a public comment period. Is there anything that local governments need to be concerned about if the public is coming in and advocating during a public meeting that may be televised, that may be broadcast using public funds?
Dave, would you guys look at that as part of, you know, like the cost of the electricity or the facility or whatever as some kind of expense?
I haven't seen anything that would indicate that it is. I think those aren't communications being paid for by the agency. That's broadcasting what's happening at a public meeting. So I don't see that would be an expense for the agency, in which case it wouldn't trigger the rules under the PRA.
Yeah, I agree with that. There's in two of the statutes that I talked about at the beginning, there's you know, kind of an exception for de minimis use of public resources, like if a piece of mail comes in and the receptionist, you know, forwards it, or a phone call is answered or something. And I kind of feel like a public meeting is the same concept. If, you know, people have the First Amendment right to come in and talk about the issues that are germane to that particular jurisdiction, I don't think you turn off the microphone because you're worried about campaign expenditures. I think I think prohibiting them is brings up a First Amendment question that I would be much more concerned about as a lawyer than allowing them to give a 3-minute campaign speech, which, you know, happens all the time. The line that I draw in my practice is campaigning from the dais versus campaigning from the public comment podium. I think, and I don't think this is necessarily an expenditure of funds issue, but I think when you're sitting as a public official at the dais for a council meeting, you've, you know, to some extent given up some of your rights as a public speaker. So I don't allow campaigning from the dais in the meetings that I, you know, advise. If somebody wants to make a speech about some ballot measure or something, I would advise them to get off the dais and go down speak as a member of the public. But that's the only rule, you know, that's the rule that I follow.
And then I would add, as Craig was speaking there, it reminded me that we have an advice letter. Casher, I think, was the requester, Eric Casher, a former commissioner for the FPPC, involving a city that wanted to air a debate amongst potential candidates for an office, and they requested advice on whether that was permissible. we said as long as it didn't favor any one candidate, simply airing the debate was not going to be campaign activity.
Yeah, and you guys actually, I think, have a reg on that kind of issue and basic, or maybe it's an AG opinion. I can't remember the authority now, but for campaign forums or candidate forums, or kind of workshops on those issues, or the airing of those types of activities. And basically, it's if everybody's invited, if both sides are able to participate and it's not favoring one side or the other, it is a permissible use of public property or facilities to air that kind of public information function.
That's right.
Some potential, be careful if you're an elected official on the dais, but as it relates to public comment or the public broadcasting, likely not too many concerns there.
Like everything else, we got to sit through and let them talk.
Yeah, it's not the only thing that's not agendized that comes up during public comment, right. I'm sure. So lots of comments there. Can you talk a little bit more about the social media piece? So, Craig, you essentially advised to be very careful about use of social media, particularly as it relates to paid advertising. So just looking for a little bit of clarification there, particularly, so say it's in that city or county's general communications plan to use social media advertising as a way to get out their message. Just can you explain a little bit more about what to be careful of, or what considerations to make? Is it the geo-targeting? Is it just the expense? What are the concerns there? And obviously acknowledging that case law has not kept up with the technology in this space, so it's not quite as bright line as maybe some of these other regulations.
I'll give you my opinion. Dave may have his own too. I think there's a big difference between a social media post that says there's an election on Tuesday, June 7th, find out how to get your ballot here, right? Which, I don't think anybody would argue with. Even, I guess, there's an important election on June 7th with a sales tax measure on the ballot, get informed and go vote, versus what Dave showed you with like LA County, for example, that was, it's just slogans, right? It was, I was trying to get back to the example, but their digital advertising, a lot of them were targeted, as I recall, and they said things like real help, lasting change, Measure H on the March 7th ballot. Are you ready? Go vote. That kind of targeted message that really is a slogan or a logo, to me, is what the regulators are looking for in terms of indications that this is outside the public agency's regular style and tenor of communicating. That's the way I read that case and have advised accordingly. I don't know if Dave has a different opinion of it.
Yeah, specifically for the LA County case, the digital ads were essentially the same thing as the ads they were running on TV. They would pop up when you went to a particular website. I think in terms of other digital, if it's a common way that the agency communicates with the people that live there or the constituents, it's not necessarily questionable because of the medium. It just, if it's something they often do, and this is a common way they get information out to the people who live there, that certainly weighs in favor of it being educational. Again, you're going to look at the content. So it's not necessarily the fact that it's electronic. It's just whether they typically use electronic and sort of what sort of electronic message it is that's being put up.
Okay, so more of advice to be careful about the message that's being put out as opposed to the medium that's being used, particularly if it's within something that they generally do on a regular basis.
Yeah, I mean, I think that's the big part of it. That last part is, the County of Los Angeles may do a lot of digital advertising about getting COVID vaccines or, public health issues, where to get a library card. I mean, they may spend a lot of money on digital advertising and use that as a normal way of communicating. A city of 20,000 people that doesn't do that all the time, if all of a sudden they start having Facebook ads pop up it's not been a common way of communicating before, to me, that's going to be more indicative of being associated with the election. And then you kind of take the steps from there as to whether it's normal style or tenor of communicating.
We might have time for one or two. Oh, sorry, go ahead.
Yeah, we just had a case probably 2 years ago now, I'm losing track of time, involving Bay Area Rapid Transit BART, who had put out some, using social media, I forget exactly which app, some ads, and some of them were deemed okay and some were deemed campaign activity. So if you're looking in this space, you might find some guidance from our enforcement case involving BART.
Perfect. Taking a look at the time, I think we've got time for at least one more question. There's a question related to signature gathering, and if that's an activity that a local agency can engage in. I think probably particularly as it relates to paying for signatures. But is there any guidance that you all have heard or put out around local agency participation in signature gathering to put an item on the ballot?
I'm not aware of authority on that. The authority I know is the authority to draft a measure. And in fact, I think that says once it's drafted, the effort to actually qualify it should not be paid for with public funds. But I believe it's limited, the authority is limited to drafting.
Okay. All right, we're getting really close to 2:30, so I apologize if we did not get to your question. I will put up our contact information here in just a minute so that folks can reach out after the fact if we didn't, in fact, get to your question today. But I do want to share just a few resources with you all before we jump off. I'm going to reiterate a couple of things that the SPPC said. This is my go-to, not being an attorney myself, is my first piece of advice is always to consult with your agency counsel if you have questions. They are a fantastic resource for you all. You'll see here again the SPP's website and their advice email that you can send in if you have questions. A lot of those, Dave, correct me if I'm wrong, but a lot of those advice letters and things like that would be accessible on your website that we've talked about today.
Yeah, everything I mentioned today, you should be able to find there.
Perfect. We here at ILG just updated some of our documents as it relates to ballot measures. We've got one that's just really kind of a high level, some of that content that Craig covered at the end there about permissible uses of funds and public dollars versus impermissible uses, as well as a longer kind of FAQ document. So that's another resource for you all. For those of you on the line that are with cities, the League of California Cities also has departments. I flagged here the City Attorney's Department, the State Clerk's Department. That can be fantastic resources for you all that fall into those categories, but they have a whole host of other ones for city managers, elected officials, and so forth. To my knowledge, CSAC and CSD don't have exactly that same type of organization, but they can also just be really great resources for you. They do lots of trainings and put out resources for their members in that space. So definitely look at the associations that you perhaps belong to for additional resources in this space. Just a quick way to keep in touch with ILG for new resources, for upcoming trainings, follow us on social media, or sign up for our monthly newsletter. And then we'll just get our contact information up here on the screen as we close out this afternoon. Craig or Dave or Rich, if you're still on the line, any kind of closing thoughts for our attendees this afternoon?
I mean, the only thing I would say is, again, I'd just really encourage and just sort of, again, reiterate, please make use of the resources that we have on our website, contact Dave's division and staff there, and get your questions answered. I can't emphasize that enough.
I was just going to say, in this case, ask for permission rather than forgiveness. Sometimes we've gotten into a position of doing the opposite. I think that asking in advance, thinking about it in advance is really the smart way to go and to stay out of trouble.
Perfect. And we will make sure to circulate that link around for all of you to the SPP's website as well. so that you can directly access that along with the recording and the slide deck from this afternoon's presentation. So keep an eye out for that in the next few days. We definitely want you to continue to access resources in this space and get your questions answered. So with that, I just want to thank all of my panelists this afternoon. Really appreciate you taking the time to share all of your expertise with our attendees and really walk through some of this definitely complicated and nuanced regulations as it relates to ballot measures. And want to thank all of our attendees on the line for spending part of their afternoon with us. So with that, I'll just say thank you again and have a great afternoon, everybody.
Thank you.
Thanks, guys.